Thank you, Madam Chair. Good afternoon, General Taylor. Good afternoon, Mr. Carlin. Mr. Carlin, let me turn to you for a series of questions. Last May, the White House formally announced that if a lethal operation will be considered against a U.S. person, that the Department of Justice, and I want to quote here, will conduct an additional legal analysis to ensure that such action may be conducted against the individual consistent with the Constitution and laws of the United States. Two questions. What's the role of the NSD in that kind of a review? And who in the DOJ is responsible for ensuring that the facts supporting the department's legal analysis are accurate?
Thank you, Senator. There's a process set up that involves input from each of the departments and agencies now before such a decision of that magnitude is made. And that's the policy process that's been set up by the President. In terms of the extra legal analysis that might occur, a decision of that magnitude would be made at the highest level of the department, and I would expect that before such a decision would be made, that the National Security Division, among other components, would be consulted. On the second question, in terms of the accuracy of the information that's provided, the accuracy of the information is usually determined by the departments and agencies providing it. So those that the collectors and the analysts, and they would provide then that information to the department, and that would be the basis for a legal review.
Over time, I'm going to want to drill more into those questions, and because this is, as you know, a life and death kind of process. But let me turn to another question that's about accuracy. You wrote in your responses to the committee that the decision to submit intelligence activities for legal review by the OLC is typically made by the intelligence community component that engages in that activity. Yet you also wrote that the NSD has the responsibility to ensure that the department's representations in court are accurate, and that, quote, the NSD attorneys must work diligently to understand the facts of intelligence activities and other national security-related matters that may be at issue in litigation or other matters for which they are responsible. Now, to me, those statements appear to conflict with each other. So in your view, how is the Justice Department supposed to ensure the accuracy of representations to the courts in criminal cases or FOIA litigation, I should say, and so on, without an independent review of the accuracy of intelligence community representations? And I ask that question in light of what former CIA General Counsel Stephen Preston's responses to my questions last year about the CIA's detention interrogation program were. And he wrote that the DOJ does not always have accurate information about the detention and interrogation program, and that the actual conduct of that program was not always consistent with the way the program had been described to the DOJ, and that further CIA's efforts fell well short of our current practices when it comes to providing information relevant to the OLC's legal analysis.
Thank you, Senator. Your question is important, and it's important as officers of the court that any attorney for the National Security Division, when making a representation, does everything that they can to assure that the representation is accurate, and also if they were to learn or discover that information is inaccurate or misleading, to take steps with the relevant agency in order to correct the record. There were several different decision-making processes that you've alluded to, some of which we are more involved with than others. So in terms of representations before the Foreign Intelligence Surveillance Court, that is one where our attorneys would be working to make the representations, would be working with the relevant element of the intelligence community in order to provide the necessary facts to the court. And as I described earlier to the chairman, there are a variety of mechanisms, including the attorneys, to try to ensure that accuracy, including the Office of General Counsel, the component, various inspectors general, and our oversight role and section.
I'm going to stay involved with you on this as I am with the intelligence community itself. One last question. I want to talk about Executive Order 12333, with which you're familiar. I understand that the collection, retention, or dissemination of information about U.S. persons is prohibited under Executive Order 12333, except under certain procedures approved by the Attorney General. But this doesn't mean that U.S. person information isn't mistakenly collected, retained, and then disseminated outside of these procedures. So to take this example, let's say the NSA is conducting what it believes to be foreign-to-foreign collection under EO 12333, but discovers in the course of this collection that it also incidentally collected a vast trove of U.S. person information. That U.S. person collection should now have FISA protections. What role does the NSD have in overseeing any collection, retention, or dissemination of U.S. person information that might occur under that executive order?
Senator, so generally the intelligence activities that NSA would conduct pursuant to its authorities under 12333 would be done pursuant to a series of guidelines that were approved by the Attorney General and then ultimately implemented through additional policies and procedures by NSA. But the collection activities that occurred pursuant to 12333, if there was incidental collection, would be handled through a different set of oversight mechanisms than the departments by the Office of Compliance, the Inspector General there, the General Counsel there, and the Inspector General and General Counsel's Office for the intelligence community writ large, as well as reporting to these committees as appropriate.
So you don't see a direct role for the NSD in ensuring that data is protected under FISA?
Under FISA, no. Under FISA, we would have a direct role. So if it was if it was collection that was pursuant to the FISA statutes, so collection targeted at U.S. persons, for example, or collection targeted at certain non-U.S. persons overseas that was collected domestically, such as pursuant to the 702 collection program, that would fall within the scope of the National Security Division. That's information and oversight that we conduct through our oversight section in conjunction with the agencies, and we would have the responsibility in terms of working with them to inform the court if there were any compliance incidents and making sure that those compliance incidents were addressed.
Yeah, I think, and my time's obviously expired, but I think you understand where I'm coming from here. One is to make sure the DOJ and you and your capacity have the most accurate information so that you can represent the United States of America and our citizens in the best possible way. And secondly, that you have a role to play in providing additional oversight. Those are all tied to having information that's factual. It's based on what happened. And again, I'm going to continue to look for every way possible to make sure that that's what does happen, whether it's under the auspices of the IC or the DOJ. You all have a joint responsibility to protect the Bill of Rights. Thank you.
Sure.